So we're going to move on to our next speaker. We have Raymond Meneses, who's going to be talking about taking the pain out of dealing with employees performing poorly and acting badly. How many of you here have employees in your practice? Okay, a few of you, yeah. So dealing with people is sometimes harder than AI is sometimes easier to deal with. Raymond Meneses has a deep theoretical and practical understanding of all facets of employment law, backed up by a quarter of a century of experience in that field. He's a skilled litigator of employment disputes and a seasoned negotiator in resolving such disputes. Being solution-driven, Raymond always seeks the most cost-effective and expeditious resolution to any employment challenge or conflict. With many experience as a specialist litigator in the CCMA, bargaining councils and labour courts, as well as being the executive responsible for employee relationships for mass discounters throughout the African region, he brings both specialist legal expertise and practical coalface experience to the table. Thank you and welcome, Raymond.
Afternoon, everyone. Can you hear me okay? I'm going to be talking today about navigating the difference between misconduct and poor performance, which can be a challenge because sometimes the same set of facts can give rise to either of them depending on the context. And I find, having dealt with employers for many years, that this is something that many employers really find challenging. And that's especially challenging when your team is small. So I'm hopefully going to be giving you some handles on how to approach it. I'm going to try to make it simpler and try to establish some ground rules for how to deal with this on a day-to-day basis. How many of you are or have been married or have been in a serious relationship of any description? Raise your hand. I imagine it's most of you. Most of you have had parents, yes? That's how we get here. And I'm sure that many of you will have had children. I want you to think about every conflict you've ever had with your significant other, with your child, with your parent, with your employer, with your employee. It was only ever about one thing. What was it? One thing. You only ever fight about one thing. What do you think it is? Money. What about money? I ask this question often to married people, and the top three answers are money, children, and sex, not necessarily in that order. But what about money? What to spend it on? Okay, we're getting closer. We're getting there. But every single fight is about this one thing. Communication of what? Communication of? Your own belief or? The lack thereof. Okay. I'm going to put it slightly differently because you're actually right. Every fight you've ever had, every conflict, every disagreement, every argument has been about an expectation that you had that wasn't met, or an expectation that somebody else had of you that wasn't met. Right? Now I'd like you to think about the employment context. Every performance issue and every misconduct issue is about an unmet expectation. That's all it is. In fact, we can take it further. Every contract is a record, a written record, of the expectations between the contracting parties and the consequences for failing to meet those expectations. We can boil a lot of human interaction down to expectations. Now, why do people fail to meet expectations? Sorry? Because you didn't communicate your expectations. That's exactly right. In most instances, the first time you think about your fights as a married person. Most expectation arguments go like this. You didn't do X. The partner says, I didn't know you wanted me to do X, right? You never asked me to. I shouldn't have to. You should know. Right? Who's had that argument? Yeah, check all you guilty people. Check, I can see it. And the reason for that is we are terrible at communicating our own expectations. We're awful at it in advance. We generally only deal with a failed expectation when it's failed. And what happens when you're in conflict? What happens to your prefrontal cortex? I'm talking to medical people. You should know what I'm talking about, yeah? Shuts down, right? Your limbic system kicks in and you're incapable of rational thought. And suddenly you revert to caveman tactics. So, just me? No? Okay. The truth is that conflict resolution is much easier if we navigate and negotiate our expectations up front. In fact, if you ever go to the CCMA, hopefully you can avoid that, but if you ever go to the CCMA commissioner is going to say, was there a rule? In other words, did you communicate the expectation? Was it communicated? Was it broken? And was the breach sufficient to warrant dismissal? So it's all about expectations. I'm going to deal with breaches of expectations in relation to performance today and in respect of misconduct, and see how they're different and how they should be treated differently. The primary difference between misconduct and poor performance is whether you can blame the employee. And that is a challenge for us as employers, because when you think of somebody not doing what they're supposed to do, you're saying, well, they're performing poorly, right? And they're to blame for performing poorly. But that's not how the law approaches it. If you can blame somebody for performing poorly, it's misconduct. If it's not their fault, it's poor performance, because it's an issue of capacity, incapacity. If you hired me to be a ballet dancer, look at my sleek figure. If you hired me to be a ballet dancer, you could counsel me, you could train me, you could give me all the guidance in the world. You could train me 24 hours a day. I'm never going to be a ballet dancer. Never. It's not in me. It's not part of my makeup. Okay? I have a brother who's a professional ballet dancer. Power to him. I could never do it. There's absolutely no amount of training that could get him to do what I'm doing now, because it's a capacity issue. In fact, if you're looking to fire somebody for poor performance, the truth is it's a recruitment issue. You've hired the wrong person. So when I speak to HR guys about this, I say, when you've got a lot of poor performance in your organization, it's not always a managerial issue. It's sometimes a recruitment issue. Okay, right. So dismissals in respect of poor performance and dismissals in respect of misconduct are both governed by the Code of Good Practice issued in terms of the Labour Relations Act. And poor performance is issued as dealt with as a form of incapacity. If you get nothing else from today's talk other than my really cool example of expectations, this is all you need to know, really. Misconduct, the employee's at fault, it's called a fault dismissal, and this is how the CCMA commissioners say, he should have, he could have, he did not. Misconduct. Poor performance, on the other hand, is should have. That should say could not have. Oh, typos. Somebody's going to get performance managed now. That should say could not have, did not. And that's the distinction, right? Dismissal for misconduct is the ultimate sanction, usually, except in extreme circumstances. You dismiss for misconduct as part of progressive discipline. So usually there's a warning, there's a written warning, there's a final written warning, then a dismissal. Not in every circumstance. If somebody commits fraud, you don't get a graded approach to that. One instance is sufficient to dismiss. It very much depends on the context of the organization, it depends on the position that the person occupies, but it's the norm to look at progressive discipline. Why? Because it boils back to expectation. How did the employee know that this was not right? Well, they got a warning. And they got a further warning. And if they didn't listen to the further warning, maybe dismissal was the way to go. Also bear in mind that dismissal for misconduct is never punishment. Sometimes employees think that way. They think, why am I being punished? No, they're not being punished. It's never a punishment. It's an expression of the management of operational risk. The employer says, can I risk leaving this person in my employment? If the answer is yes, you don't dismiss. If the answer is no, you dismiss. It's about managing risk. There's nobody in front of me who can risk having somebody employed by them who steals money. There's no ways you can do that, right? Are any of you happy to keep a thief on your books? No. Okay. What about a rapist? No? Well, how does that relate to the risk profile of your business? It does from a reputation perspective. So maybe you can't. But it depends on the facts. Don't worry about Section 188. Dismissal must be substantively fair. In other words, there must be a fair reason for the dismissal, and it must be procedurally fair. The employee must have an opportunity to state a case in response to the allegations against them. It doesn't have to be a formal hearing. It's preferable to be a formal hearing if you're going to dismiss. But sometimes that's not appropriate, sometimes it's not possible. You can do it in an informal basis up to a final written warning, and only have a formal hearing if you're going to dismiss. Also, sometimes the employee isn't physically present, then you can do it by exchanging emails. The important thing is that the employee is given the opportunity to be heard, to state a case in response to allegations against them. To dismiss fairly, you must establish that a rule or standard was broken. This is for misconduct. The rule was reasonable and known to the employees. The rule was consistently applied, and dismissal was appropriate for the offence. That's a summary of what you're going to put into the slot machine to achieve the outcome of a fair dismissal. I want to comment a little bit about what constitutes a fair hearing. When the Labour Relations Act was written in 1996 and the Code of Good Practice was issued in terms of the Act, the legislature specifically said we are moving away from the criminal style of disciplinary hearings where you've got a prosecutor and a charge sheet and an accused employee and dismissal as a punishment. We're moving away from that. That's criminal. That's not what we're dealing with. We can't expect employers to conduct what amounts to a criminal trial in the context of the employment relationship. It's not reasonable. It's not rational. What they said is, we're going to simplify this right down. We're going to say the employee must be given an opportunity to tell their story in response to allegations of misconduct. And the employer says, do I accept this story or not? And if I don't, is the trust relationship destroyed or not? It's really very simple. But we're creatures of habit, right? Humans are creatures of habit. And many HR people have 10, 20, 30, 40 years of experience of dealing with employees who've committed misconduct as if they're criminals. You don't have to do that. It makes things so much more aggressive and unpleasant. It's already unpleasant. You don't have to do that. All you have to do is say, well, this is what we say you've done. What do you say about it? Lead evidence. Get other people to talk to what they've seen with their eyes, what they've heard, what they've observed. But really try to take some of the heat out of it. Because frequently I find employees and employers alike become very wound up in the process and sometimes lose sight of what they're dealing with. These are the steps that I recommend should be part of any serious disciplinary inquiry process. When I say serious, it's looking at a final written warning or dismissal. Investigation, a clear notice of the charges. I don't like charges. I prefer allegations of misconduct. A disciplinary hearing with an opportunity to respond. Decision and a reason for the dismissal is provided. And the employee is informed of their CCMA rights. The only right you need to inform them of is that they have 30 days within which to refer a dispute to the CCMA. And that's not a legal requirement, it's just good form. I'm going to deal with a few specific forms of misconduct because I want to compare these to poor performance. Dishonesty. Not every instance of dishonesty warrants dismissal. Do you agree with me? Do you agree? Disagree? Okay. Do these pants make me look fat? If you lied to me about that and I was your employer, that's not dismissible, right? Because none of us are 100%, you're blushing, it's quite funny. None of us are 100% truthful all the time. Most of us lied to our kids about the Tooth Fairy and Father Christmas and the Easter Bunny. Most of us did that, right? Not every form of dishonesty results in a dismissal. However, dishonesty is nonetheless very serious because you're entitled to rely on your employees to tell the truth. And what they do has an impact on how serious any form of dishonesty is. If somebody's working with money, the level of honesty has to be very high. If somebody is only ever making tea for your patients, I can't imagine that would ever happen, but I'm using a strange example, then if they lie about something, it's less likely to be as serious because the risk that they pose to the business is smaller. So it depends on the context. If a senior employee, somebody who's in a position of authority, who supervises others, lies about just about anything, that might warrant dismissal because of the position of trust that they occupy. Even a small theft can justify dismissal if trust is broken. Again, it depends on the context. In the retail context, if as an employee you steal a single chappies, that's dismissal. There's no ways you'll survive that. Go to the CCMA until you're blue in the face, your dismissal will be upheld. If you work for a manufacturing plant manufacturing cars and you steal a chappies, less likely because the risk that you pose to the business is smaller. Because in a retail environment with lots of small, fast-moving consumer goods, stealing small things a lot is a high risk. In an automotive factory where we're building cars, a theft of a small thing is a less of a risk. If you do go to the CCMA, the line manager is the only person who can testify to the destruction of the trust relationship. Just bear that in mind. In Edcon versus Pillimer, we've got a little bit of time for me to tell you an anecdote. Edcon versus Pillimer, person who occupied a financial position, she was a manager in finance, lied about her teenage son having damaged the company car. She had it repaired without disclosing it. She lied when she was asked about it. She submitted a written statement that was a lie about it. She then lied in the disciplinary inquiry and finally admitted, actually, I lied. And the Edcon dismissed her. Completely justifiable. Edcon made the mistake of not calling the line manager. They only called the HR manager. And Bess Pillimer, who's the chairperson, who's the commissioner, said, well, HR can't tell me if the trust relationship is destroyed. Only the line manager can. And she was reinstated. So the line manager must testify. The test is whether the employee's action has had the effect of rendering the relationship of employer and employee intolerable. Just very briefly, I'm just going to touch on this. Employers frequently misconstrue the distinction between insubordination and insolence. They're two different things. Insubordination is the refusal to comply with a reasonable and lawful instruction. Insolence is serious disrespect. So, I'll give you an example. If I go to my employee and I say to my employee, please do this, and she looks at me and tells me, F off, but then complies with the instruction, what has she done? Insolent, she's been rude to me. What if she tells me to F off and she doesn't comply with the instruction? Then she's insubordinate. Okay, always depends on the facts. So, insolence generally in the first instance is not sufficient to warrant dismissal. Insubordination might be, but it's got to be serious, and it has to have the effect of undermining the authority of the person giving the instruction. It's not common to dismiss an employee for one instance of insubordination. Sometimes you have employees who are just difficult and consistently challenge the authority of their line manager, usually after a couple of instances, a final written warning before dismissal takes place. Alcohol and drugs. Here's an interesting one. The use and cultivation of marijuana for personal consumption is now legal, right? Okay. I'm talking to doctors. How long does THC stay in your system? Quite a while. Days, sometimes weeks. Yeah, depends. It's absorbed by the fatty tissues of the body, especially your brain, and can be released randomly from time to time. It is not a quantitative, having THC in your blood or urine test is not a quantitative measure of inebriation the same way that alcohol is in a breathalyzer. So if somebody smokes weed on the weekend, where they're allowed to, and they arrive at work with bloodshot eyes and smelling like weed, what do? Sorry? What do you... Warning, for what? What have they done wrong? Well, you've got to demonstrate that they're under the influence, right? Which you observe. They walk funny, they speak funny, they got the munchies. No, I'm kidding. But it becomes difficult. So I recently had a client approach me and say, we work in a very high-risk environment with heavy machinery. If somebody's hand goes into one of our machines, they'll lose their hand or their life. It is very dangerous. We have always had a zero-tolerance policy when it comes to marijuana at work. Do we need to adjust our policy having regard to the fact that it's now legal? And my advice was, no, you don't. You have to communicate it better, but you don't, because you can't take the risk of the security guard who provides access to the premises, or even the line manager picking up whether this person is under the influence or not. How would you know? So if somebody tests positive, I say you're entitled to say, hey, I'm going to deal with this as a form of incapacity. In other words, the person who works for this organization can't have marijuana in can't have THC in their system. Or if, alternatively, and this is a good example of how they're different, it appears to me that you're under the influence at work, I'm going to exclude you, I'm going to take disciplinary action, I'm going to fire you. But you've got to communicate that up front. I've said to my client, you've got to do a bit of a campaign, you've got to issue a policy, here's the wording of the policy, you've got to communicate, so nobody can say to you, I didn't know. Okay, really important. It also depends on what they do. You know, if somebody is under the influence of THC, marijuana, and they're cutting sugarcane in a field, there's quite a lot of research to indicate that their productivity increases. Monotonous, boring, drudgery work, THC actually helps. What if you were climbing on an airplane this morning and you noticed that your pilot has a marijuana leaf on their lapel? Not so happy about that. It depends on what you do. If somebody's driving a tractor, I don't want them under the influence of THC. If they're cutting cane in the field, same field, probably less of an issue. Depends on the facts. Right, alcohol, you can use a breathalyzer. It's less of an issue for you lot, but it's certainly an issue in the manufacturing environment. Dismissal for incapacity is a no-fault dismissal. In other words, the employee is not blameworthy. Can take the form of poor work performance or ill health and injury, and medical incapacity includes addiction to alcohol and drugs. That's where that is dealt with. So whilst an employer is not obliged to pay for an employee who needs to go to rehab, you do have to provide sick leave. Also, bear in mind that you don't have to wait for an employee to exhaust their sick leave before you go down the incapacity route. Because somebody who provides a vital service in your organization, you can't wait for 6 weeks while they sort themselves out. Okay. Again, it depends on the facts. In a law firm, we can put up with the absence of a senior attorney like myself for months. We're okay. But our messengers, if our messengers off for a day, the firm's in trouble. So it's not a question of seniority. The question is, what is the impact of the absence of this person going to have on the operations of the business? Which is quite sobering, like they can do without me, but not without a messenger. Poor performance incapacity. Set clear performance standards. One of the steps I find my employer clients frequently miss is probation. Probation, that first 3 months, it can be 6 months, but 3 months is normal, where you say to an employee, a new employee, you're subject to a probation period. What employers sometimes do is they say at the end of the 3 months, you know, this hasn't worked out, we're letting you go. You're going to be in the CCMA. What you're obliged to do at the beginning of the process is say you're on probation. This is what I expect of you. These are our expectations. When they're not meeting those expectations, you counsel and guide through the probation period. Before the probation period comes to an end, have a hearing and dismiss. The CCMA will not interfere with it. If you've guided and counseled and had a hearing, probationary employees, 99% of the time the CCMA is not going to upset a dismissal. If you haven't guided and counseled and have a record and had a hearing, they will interfere with your dismissal. So probation is very important, but even beyond probation, set clear performance standards so people know what is required. What I find to be very effective is to actually sit with the employee and work it out together. Because then the employee can't say, you're imposing something on me I can't do. So no, you participated in the process. You signed off on this, and now you're not meeting it. Offer training and support, provide warnings and opportunity to improve, and hold a hearing before dismissal. When it comes to poor performance, I would say to you that the vast majority of what we call poor performance is not poor performance, it's negligence. It's the employee is capable of doing the work, they're not doing it for a range of reasons. They're bored, they're irritated with the manager, they have other stuff going on in the background. If there's other stuff going on in the background, we might be facing a medical incapacity situation, because if they're depressed or suffering from anxiety, then that now becomes medical incapacity, and we've got to deal with it on that basis. So it's quite important to have a heart-to-heart conversation with the employee and say, what's happening? We know you can do the work. You're not doing the work. What's the reason? And they're going to lie to you. They will not be truthful, generally, up front, because they're worried about their job security. And it takes some patience, and it takes a little bit of engagement and genuine empathy to get employees to disclose, actually, no, this is what's going on in my life. There's a divorce, someone's sick, someone's suffering from some undisclosed challenge, and that has a bearing on things, and then you offer the support that's required. Note that higher standards of competence and performance are required of senior or managerial employees, much more than garden variety employees. Is that surprising? You know why? It's because they're a higher risk to the organization. If the person who makes your tea makes bad tea, not a risk to the business. Okay? If the CEO doesn't understand a spreadsheet, you have a problem. So the further you go up the food chain, the less room there is for error. To dismiss fairly for incapacity, you have to prove the employee knew about the performance expectations, the employee was given support and opportunity to improve. I think this is a little bit too strong that dismissal was the only option left. I would prefer to say dismissal was the appropriate outcome, having regard to the operational risk that their continued employment posed to the business. It always comes down to operational risk. You're not obliged to keep an employee who can't do what you've employed them to do. I was chatting to an occupational health specialist at one of these seminars I was presenting a few years ago, and we were talking about medical incapacity and accommodation, because there's an obligation on an employer to accommodate employees' incapacity, medical incapacity, especially if there's an injury on duty. There's a higher obligation on the employer to accommodate the employee. And she told me that she dealt with a case with a mining house where an employee, a miner, who worked at great depths, was involved in a terrible accident, and he was left with one finger, this finger. That's all he had left. Lost 9 fingers, was left with this one. So at least he was capable of communicating his displeasure. But generally, you'd expect that to be quite a negative factor. And what the employer did was that they got this employee to operate the high-depth hoist. So bringing miners up from great depths, kilometers down, because he could operate the button. And he knew about the risks of operating at depth. He was a perfect candidate. So that person remained in employment until they were either dismissed or retired. That's the broad distinction. Negligence can perform but doesn't care. It's not always that they don't care. Sometimes it's that they haven't applied themselves, even though they're capable of applying themselves. It's misconduct, poor performance, tries to perform but can't meet the standards, incapacity. Also bear in mind with incapacity, if somebody's not good at one job, that doesn't mean they can't do another job. If you hired somebody, for example, as a salesperson, and they're terrible at sales because you actually discover, now this person's an introvert. We hired the wrong person for the role. They might be good at a clerical position. I understand in the medical context there's less room to maneuver, but just bear that in mind, that sometimes just trying somebody out in a different role can solve the problem. For ill health or injury, I'm not going to deal with this in any detail, but bear in mind that there's a distinction between temporary and permanent incapacity. Even if incapacity is temporary, it may warrant dismissal if the absence or diminution of capacity is longer than an employer is expected to put up with. So again, a messenger can't be gone for 4 months. Even if I know in 4 months' time they'll be okay, it's too long. I'm going to have to replace the messenger. Also bear in mind that depression is a form of medical incapacity which can warrant dismissal. It's terrible, it's very harsh, but that's a fact. The leading judgment on that was from a municipality, and I remember reading the judgment and thinking, deep as if I worked for a municipality, I'd be depressed too. But there it is, Witzenberg municipality. And the court held that the person's continued absence due to his ongoing and genuine medical depression warranted his dismissal. Just a few common employer mistakes, misclassifying cases, the could, should, didn't, with should, couldn't, didn't. That distinction. Skipping procedural steps, wanting to go straight to dismissal, dismissing without documentation, without properly recording warnings, for example, inconsistent application of rules. Some people got away with it, others didn't. Incidentally, on that, frequently when there's a change of management, the new manager comes in and wants to bring order where there's been chaos and disorder. And the employee says, we got away with that before. It's really important you're not bound to live with that forever. You don't have to put up with that nonsense forever. But you do have to communicate the new expectation before dismissing, unless it's really gross. I had a case, actually with one of my, I was a partner in a law firm, and the employees on a Friday afternoon, the kitchen staff, would take cool drinks out of the fridge and take it home. Like lots of it, like 20 liters at a time. And it was picked up on the camera, and we said, hey, you can't do that. And they said, no, but the previous office manager allowed us to do that. I said, no, there's just no way. And even if they did, from the video footage, you were hiding this. And it's clear that you knew you weren't allowed to do this, and they were dismissed. Rushing to dismiss without progressive discipline, that's a problem. Failing to prove the breakdown of trust, remember the line manager must speak to it. Setting unclear performance standards, and disciplining based on assumptions instead of evidence. Evidence is really important. It doesn't have to be beyond a reasonable doubt. It's just out of a range of possible explanations, which is the most likely. Which one? And that's how you test it. Key takeaways: employee's fault, disciplinary process, poor performance, no fault, support and warnings first. Fairness is key. I've got 4 minutes for questions. Great timing.
Thank you. Does anybody have any questions? No questions. You must have been really good.
No questions?
Oh, here's one here.
Thank you for the presentation. I wanted to find out actually about a patient of mine. They got injured at work and they have a shoulder, pain all through. They've recovered, but they're still having a pain. And now at work, they want to dismiss them because they can't perform. However, they never paid them for injury on duty. So
they never paid them for injury on duty, or they never reported an injury on duty?
It was never dealt with, like to reward her or something. So, but now what I wanted to know, can they give, you are saying here, can they give the person an alternative role?
Yes.
Say maybe work as a secretary instead of operating on the machine,
Yes.
Yeah.
So the question is, if somebody's injured on duty, in circumstances where the IOD was not reported to the Compensation Commissioner, which is a crime, can the employee be given an alternative role? And the answer is yes, provided an alternative role exists. There is always a higher responsibility on an employer to accommodate an employee who's injured on duty, rather than injured off duty, obviously. But really there's quite a high obligation on an employer to genuinely look for alternatives. And frequently where there's a physical injury, light duty is appropriate. It doesn't always work. I had a case where a supervisor of 5 blocks of flats who had to go up the stairs, and it was 4 stories with no lifts, had to go up the stairs and check each floor to make sure that it was cleaned every day. That was her job, part of her job. And she was involved in an accident, and she lost the use of her legs, so she was wheelchair bound. And she couldn't be accommodated. She has to go up the stairs, and she said, "But I'll send my husband." And the employer said, "Well, your husband's not our employee. We're terribly sorry. We need you to physically be there," and had to terminate. So not every case can be accommodated, but hopefully most will. Any other questions? Listen, you got free legal advice for 3 minutes. How often does that happen?
We have a question over there.
Yes, sir.
Thank you for the good presentation. Often I hear employee accusing the employer of dismissing them unfairly. I think constructive dismissal. What do you think about it?
Okay. Constructive dismissal, just so everybody's on the same page, is where an employee resigns because they say that their continued employment has been rendered intolerable, both subjectively, that person can't put up with it, and objectively, no person could put up with it. Okay? So that's the test for constructive dismissal. I had no choice but to resign. It's as if they fired me. In my circles, we call that the unwinnable case, because employees have to jump through so many hoops to prove that subjectively and objectively their continued employment was intolerable. The only cases I'm aware of, and I've done lots of these cases, where an employee has successfully pursued a claim for constructive dismissal is where there's been racism or sexual assault or sexual harassment or some form of physical intimidation, where the employee has raised it and the employer hasn't taken appropriate action to deal with it. And then they've said, well, if the employer is not going to protect me, I'm out. There have been cases, one that went all the way to the Labour Appeal Court, where an employee was legitimately, unfairly demoted, pushed around, treated badly for years. And the court said, you haven't gone far enough. So constructive dismissal, frequently attorneys who don't do employment law, who are friends of the employee, say constructive dismissal and they write you a scary letter. They don't know what they're talking about, usually.
Any other questions? So as an occupational therapist, we obviously do a lot of incapacity evaluations.
Yes.
And I find there's obviously the physical, I do more the mental health side. I find it quite shocking that a lot of times when clients come to me and they're paying it out of their own pocket because the company doesn't have those resources, but I find it quite shocking that often the employer is not keeping record of, you know, some kind of intervention.
Crazy, hey?
And then I'll ask them, but now when they've had these meetings with you, do they not take minutes, give you copies? You should ask for it. No, the manager just called me into the office and then had a chat with me. And then that's it. So there's no actual record. So I don't know, how do employees kind of navigate that situation?
So it's to the employee's advantage because the employer bears the burden of proving that the dismissal is fair ultimately. And if the employer can't produce minutes, they say, well, that's not what we discussed. How do you know? So bear in mind, 90% of the time more, I'm acting for the employer. I say to the employer, hey, the line manager and HR, or if you don't have HR, someone else needs to be there so that you've got a witness to what happened. You need to have notes, you need to produce minutes, and you need to get the employee to agree that those minutes are accurate. And if they dispute that they're accurate, tell you in which respects they're not accurate. And do that within a day or two of the meeting while everyone's memory is fresh. So I think that employers fall down, especially in a small environment, because they deal with it very informally and don't keep accurate records. I think that's a problem. Because if you want to deal with it further down the line, you've got no record, it becomes hard. And it's unfair to the employee.
Yeah, and then also on the case of accommodation. So obviously, often we have clients where they do have incapacity, but you have to recommend maybe first like a reasonable accommodation, but with the emphasis being on a reasonable.
Yes.
And I always find it quite difficult for that employers aren't always forthcoming with the information I need to actually show that actually they don't have reasonable.
Yeah.
Like, I don't know if it's because they think I'm on the side of the patient, but like I need to show that actually these are what I'm recommending as reasonable accommodations, but it doesn't make sense for you as a business. You would go out of business if we expected you to like build a whole new, room or whatever. So how would you recommend as medical professionals, we often deal with that situation with employers. How do we communicate to employers to let them know that it's in their best interest for us to understand their business and the implication on their business to make these accommodations?
Generally, people don't cooperate out of, generally, this not just in this situation as a general rule, out of a fear. There's some fear driving that behavior. So what I say to professionals such as yourself is identify the fear and then address the fear. So, for example, I would say to an employer, look, I can understand why you would be nervous about disclosing all kinds of confidential information about your organization and being stuck with somebody in a role that they can't do. I get that. That's not what this is about. That would be to the employee's disadvantage too. What we're looking for is a win-win for you and for the employee. Tell me what you have. If you don't have anything, that's cool. Then we can talk about that. But maybe there's something here that's to your advantage and to the employee's advantage. Because an average dismissal costs an employer, depending on seniority, anything from 200,000 to R1 million, sometimes more, in lost opportunity cost, recruitment, training, a whole range of things. There's a spreadsheet that deals with all those things. But most employers don't actually want to dismiss employees because it's expensive, it's a hack. So what you do is you address the fear. What's the underlying fear? And just be reasonable. It's very difficult to resist reasonableness.
Thank you. Oh, there we have another question.
Raymond, in our businesses, an injury on duty isn't something like falling down a mine shaft. The
True.
realistic thing would be something like a needle stick injury.
Yes.
How do we deal with that? Who bears the burden, or are the employers responsible for the cost of treatment? And let's say the nurse or practitioner does become HIV positive from that. Is the employer then obliged to pay for the ARVs lifelong? How do we manage something like that?
That's such a great question. That's a classic IOD. So what you have to do is you have to, as soon as you possibly can, report that to Compensation Commissioner and go through the channel. You will not bear the cost of the ARVs. nor should you generally, although it's slightly different because you can offer the services in-house, I suppose, but you would generally not be responsible for the medical costs either. There are needle stick protocols. You know, I don't have to tell you what the needle stick protocols are, but there's systems in place to accommodate that.
Thank you so much. Any other questions? There's one over there.
Good afternoon. In terms of employing somebody, for how long can you keep somebody on a contract if the person is not permanent?
Okay. The legislature, so the government, doesn't like fixed-term contracts. And they've been waging a war against fixed-term contracts for years now. And the most recent amendments to the Labour Relations Act and Basic Conditions of Employment Act came out a few years ago, said if somebody is earning below the threshold, the ministerial threshold, it's about 20K a month, any fixed-term contract more than 3 months, unless it falls into one of the categories of exceptions, is deemed to be a permanent employment contract. If they earn more than 20,000 Rand a month, if the employer has created a reasonable expectation of continued employment, either a renewal or indefinite employment, then to terminate the contract, to not renew it, is an unfair dismissal. So it depends on the context. If you have a fixed-term contract for a project, I'm building a hospital, I need a project manager to oversee the building of the hospital, and the project's going to take 2 years. That's a fixed-term contract for 2 years. It doesn't matter if they earn 300,000 Rand a month. We're good. Everybody knows it's going to come to an end. You don't need a project manager beyond that. If you have a permanent role and you appoint somebody on a fixed term, the court and the CCMA is going to look at that and say, why are they on fixed term? Why isn't this a permanent position? Are you trying to erode the rights of the employee? So it depends on the facts. Does that answer the question?